Hello guys, welcome back to my channel. Today I will talk about the Supreme Court of India. Unlike the American Constitution, the Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the High Court below it. The single system of courts adopted from the Government of India Act 1935, which enforces both central laws as well as the state laws. The Supreme Court of India was inaugurated on January 28, 1950, and it succeeded the Federal Court of India, also succeeded British Privy Council as the highest court of appeal. The Supreme Court of India in the Constitution, Article 124 to 147 in Part 5 deals with the organization, independence, jurisdiction, power, procedure and so on. And the Parliament is also authorized to regulate them. The appointment of judges are made through the collegium system, where the name of judges are recommended to the president, and the recommendation by the collegium system is binding on the president. However, in the Constitution, there is no mention that the minimum age to become a judge of Supreme Court or High Court, but some qualifications are enumerated, like he should be a citizen of India, he should have been a judge of a High Court for 5 years, or he should have been an advocate of High Court for 10 years. The Constitution has conferred a very extensive jurisdiction and vast power on the Supreme Court because it is also the final interpreter and guardian of the Constitution and guarantor of the fundamental right of the citizen. Therefore, Aladi Krishnaswamy Iyer says that the Supreme Court of India has more power than any other Supreme Court in any part of the world. So the jurisdiction and powers of the Supreme Court can be classified into the following. First is original jurisdiction, second is writ jurisdiction, third is appellate jurisdiction, fourth is advisory jurisdiction, and fifth is a court of record, sixth is power of judicial review, seventh is constitutional interpretation, and eighth is other powers. In original jurisdiction, it deals with the center or one more states, between the center and any states, and between the two more states disputes. And in the appellate jurisdiction, it deals with the civil matters, constitutional matters and the criminal matters. And also in the writ jurisdiction, it can issue writs only for the fundamental rights, not for the other provisions. Advisory jurisdiction, under the Constitution, Article 143 authorize the President to seek the opinion of the Supreme Court in the two categories. One in question of law, and second is the dispute arising out of any pre-constitutional treaty, agreement or etc. In the first case, the Supreme Court can deny to give their opinion, but in the second case, Supreme Court must give their opinion to the President, and the opinion given by the Supreme Court is not binding on the President. With this, I am ending the video here. I hope you will like the video. So please like, share and subscribe to my channel. Jai Hind.